6 of us AGs were there, and several others were on the phone. And we discussed technology companies and antitrust issues and privacy. That was our primary concern. As attorneys general, we have privacy authority under the Consumer Protection Acts, as well as antitrust acts in the state, and so that was our primary focus. There was a bit of conversation about bias, on the internet, but that involves First Amendment issues, and so we didn't really talk much about that. But we're optimistic that the Department of Justice is going to take a really close look at it. Some of the antitrust issues that have cropped up, since the Microsoft litigation, there hasn't been much going on in the antitrust area. A lot of it because in the end, the government lost. On appeal, they lost on appeal, but it changed the way Microsoft operated, because their executives wanted a lawyer in the room. When they started talking about issues that might involve antitrust. And so it changed the environment. And of course, Google claims that they cropped up because they had a better product. Well, they didn't. That was not true. What happened with Google is Microsoft, their executives were more cautious in the area of antitrust, because in the discovery, in the Microsoft case, y'all remember I settled that case with them probably 8 or 10 years ago, our separate state case. There were emails where some of the Microsoft engineers were talking about blocking search results for Google. So Google had Microsoft had it not been some of that antitrust litigation going on, Google may not have ever existed, because Microsoft could have basically just stamped them out. And so that's what now Google's doing to a lot of the small companies around. And it wasn't just about Google. It was about, all the other big tech companies. I mean, they're the most wealthy corporations in the world are tech companies now. Many of them don't build anything. They just trade in information, with the exception of Apple. But they trade in information, which is now the gold standard. And so it used to be the federal government was big brother, and now it's the tech companies. They know more about us than we know about ourselves. So we're hoping that the Department of Justice will join with attorneys general. My suggestion I put on the table was for us, we AGs who are interested in the antitrust area involving tech companies, to form a working group, that we sign a memorandum of understanding whereby documents will be kept confidential and we could share information. I have litigation ongoing with Google now over mining our children's data in the high schools where they had Gmail accounts. If y'all recall, I filed that several years ago, and in that case, they have written agreements that say to the schools and the universities in Mississippi and all the other states as well, that we're going to give you this free email service, and we won't mine the data of the people who have those accounts. But in fact, they did. They settled a class action suit with the individual several years ago. And so, we went in and checked at the schools, and sure enough, they were mining the data. They were profiling a kid. And profiling a kid, you advertise that person for 50 years, so that's the most valuable profile you can have as an advertiser. So that's why they went out, and if a kid is interested in riding horses, they'll advertise to them, or tennis, or whatever their interests are. They profile them, and so we would be glad to share our information with the Department of Justice on that type of litigation, as well as our investigative information. Now, European Union did a test just specifically on Google. They did a test. They did searches of 1.7 billion queries where they asked, information in a search, and they knew which ones Google had an interest in. In other words, where they made money. And they push things up in the search results and so forth. And out of that 1.7 billion searches, which is a huge undertaking, they found that Google was using their economic power to stamp out competition and to benefit themselves. And so that's what resulted in a $2.7 billion, I believe it was, penalty from the European Union, which has led in the area of privacy and technology. And so antitrust and privacy issues, they sort of merge when you start talking about information being the gold standard, because our problems as AG is how they obtain that information, mining data of children and so forth. But also, once you get it, protecting it and stamping out competition, and so we're encouraged by it. Litigation in antitrust area has been very beneficial to businesses historically. I mean, IBM was sued in the 60s. LBJ sued because they were coupling hardware and software, even back then. And that's how the software industry has risen, and the software industry has done great. Same thing goes for AT&T and that type of litigation. Some of the tech companies want to go, well, our antitrust laws are antiquated, and we shouldn't apply to tech companies. Well, the fact is Standard Oil. Remember that antitrust litigation? Standard Oil was about technology, because Standard Oil excelled because they learned how to refine kerosene. So it was about technology even back then. So coming away from that meeting, we AGs hope that we will be able to work with the Department of Justice going forward to use their forces and use our separate state laws to try to bring forces to bear to deal with some of the power of the tech companies. And at some point, we're going to have to address that economic power, and hopefully in the end we'll be able to create more, so we can create more competition in the marketplace.